Attorney's fees and cost. Contingent fee, hourly fee, or some type of hybrid. Which option is likely to be most cost effective for you? It depends. Oftentimes clients needing collection services or judgment enforcement aren't sure what attorney fee cost option may be best for their situation. Generally, in a very simple way, there's three options. One, a straight contingency. Two, a straight hourly. Three, a hybrid, where we have some aspects of both contingency and hourly. As far as the straight contingency, that's meaning a certain percentage for recovery of what gets obtained from the target debtor. My office does not get paid unless we recover money from the target debtor. The positive for the client is you don't have to pay attorney's fees unless there's money recovered from the target debtor. The negative is if the debtor pays quickly and recovery is obtained with little effort, the percentage that my office obtains may be much higher than you would have normally paid in an hourly situation. Depends on the circumstances, not able to predict fully how it may turn out. Again, depending on the factors and the circumstances involved, we can make a suggestion, and again, you can make the call on it. Second way, straight hourly fees. It's where I just charge an hourly fee based upon the actual time spent on your case or the staff spends on your case. Some cases result in a rapid recollection. Others take extensive effort to collect. A few require extensive effort, but do not result in a favorable outcome. There's no way to predict in advance with absolute accuracy how things will play out. Hourly legal work will generally require an advanced retainer at subsequent billings as the litigation progresses, if it's a situation involving litigation. Again, if the case resolves quickly, hourly fees can be extremely cost-effective for the client, particularly in large cases. If you have a lot of cases and can play the odds, hourly fees may also be the best way to proceed for you. With a hybrid, some aspects of both. We both assume some risk in pursuing the matter and work financially as a team in terms of the financial commitment and the percentage return if we're successful. The straight answer is really as far as what's best, it depends. Depends on the specifics. But again, you can decide in advance after we've talked about all the details. Each approach has its advantages and disadvantages. Depends on the financials and the factors. Such circumstances as one, what are the characteristics of the debtor target? I can now provide, after discussions with you and getting documentation regarding the debtor target, a much better idea of what is likely to work. Two, the likelihood of recovery. Again, it's related to the circumstance and characteristics of the debtor target. Third, the intensity of the litigation. Is there no litigation, or is it going to be moderate litigation, or is it going to be extensive, drawn-out litigation? Again, depends on what the circumstances may be. Fourth, the risk-reward level you're comfortable with. And five, to what extent you may or may not be willing to compromise the total amount of recovery for getting your money fast. What I want is an approach that's cost-effective for you. It's best for all of us, my office and for you personally, if we can cost-effectively solve your collection problems. Then we'll work with you for years. Have a satisfied client we feel good about, you feel good about us, it works for both of us. We want this to financially work for you. Again, it's best for us all the way around. Not always, but most of the time, there's always a risk of putting time and effort in a matter and it not coming out well. There can be no advanced certainty regarding how much legal work is necessary for a dispute, how long the process will take, or whether it's economically justifiable to even incur legal fees in the first place. That's why we always engage in an investigation up front to get a better idea of what's going on. Some debtors file bankruptcy, some become insolvent, some die, or disappear, or conceal their assets to the point of criminal fraud. It happens. Others settle quickly. Winning cases is generally far easier than collecting the money. Again, you proceed with the litigation. Sometimes they'll settle because they don't want to incur the litigation cost. Other times you have to go all through the way to getting a judgment, and then you have to engage in judgment enforcement. It just depends. Very generally, hourly fees tend to work well on solid claims where there's a first claim position as to a readily marketable asset and a debtor target which has resources, but it's just playing hardball to see if he'll do what's necessary to get paid. Contingency generally works well where the dollar claim is relatively large and more questionable in terms of the ability to recover. That way, it tends to work out as far as a closer comparison regarding actual hours spent and the compensation obtained, which again can be good for both of us. I'm generally able to provide representation either way depending on the amount of the debt and what the initial outlook appears to be after the investigation, based upon your desires and also all the factors referenced. Again, give me a call. We can discuss your particular matter at issue, or whether there's a series of cases you need some work on. I'll do my best to try and let you know how I feel the situation is in terms of, again, the likelihood of collecting, and under what circumstances, what strategies may best work for your situation. Then, depending on the circumstances, you can think about things, analyze a little bit further, and we can try some cases, see how it works for you financially, about how we can pursue them, and go down the road from there. Hopefully we can have a long and fruitful relationship. Again, give me a call. My office is more than willing to set up a conference at your convenience, and we'll see what we can do for you.